What's up, guys? Today is August 25, 2017. I have two editorials from The Hindu, so let's start it. Citizen versus State on the right to privacy verdict. In a rare unanimous verdict pronounced by 9 judges, the Supreme Court has ruled that privacy is a fundamental right that requires constitutional protection. It was always known or assumed to be a common law right. Occasionally and somewhat grudgingly, it was recognized in some verdicts as a fundamental right. In concluding that the right to be left alone is an inalienable part of being human, the court has restated a fundamental principle, namely that some rights are natural and inherent. Constitutions only recognizes them and make them explicit. This restatement of first principles became necessary mainly due to a strange and pervasive argument by the Union government in the course of the hearings on the validity of its Aadhaar based unique identity scheme that privacy is not a fundamental right. The fact that all the judges unanimously came down on this argument shows how much the government misunderstood the constitutional underpinnings of privacy as a value in itself and as an ineluctable fact of human dignity. The government argued that privacy is so amorphous as to defy description that it is needless to call it a fundamental right as it is one in common law, and that it has been given statutory protection in different forms. There was even a suggestion that privacy is an imported value and that it is illicit. All these arguments fell by the wayside. The outcome was not entirely unexpected. Not many would have seriously believed a constitutional court would rule that privacy is not a cherished right in a democracy. What implications the ruling would have on state policy and citizens' right will be the core issue in future. A welcome aspect of the judgment as that it makes it clear that sexual orientation is part of privacy and constitutionally protected, and that the 2014 verdict uphold section 377 of the Indian Penal Code is flawed. This opens up the case for a much needed reconsideration. As for the Aadhaar, it is pregnant to note that the judges have referred to the restrictions and limitations that privacy would be subject to. The test to decide the validity of any such restriction is that it is reasonable, based on fair procedure, and free from arbitrariness or selective targeting or profiling. It can also be based on compelling state interest. This is where a cautionary note is in order. Courts exercising writ jurisdiction should be cautious about the nature of the relief they grant based on wide and open ended claims of breach of privacy. The verdict has advanced and revivified core constitutional principles in an era in which privacy is pitted against state interests. Somehow, privacy as a value finds itself at loggerheads with no notions of national security, the needs of a knowledge society, and even socio-economic policy. Hopefully, this judgment will set many such concerns at rest and bring about a more equitable relationship between citizen and state. The second editorial, Caste and Class, on OBC subcategorization. There are inequalities, and then there are inequalities within unequal entities. That reservation in jobs and education did address socio-economic disparities in India to some degree is true, but equally the benefits of reservation have not been distributed equitably, and large segments of the weaker sections and backward classes continue to have no access to quality education or meaningful employment. The relatively rich and dominant sections among the backward castes have tended to take up a disappropriately larger share of the reservation pie. The introduction of the concept of creamy layer to isolate the well-off among those eligible for reservation was initially perceived as an attempt to limit the benefits of reservation and to politically divide the beneficiaries of reservation. But properly implemented, it could have had the effect of allowing a more equitable spread of the benefits of reservation. The Union Cabinet's decision to set up a commission to examine the issue of subcategorization of the other backward classes speaks to the longer years of failure of ineffectively preventing large section of the creamy layer from taking advantage of the quota system to detriment of poorer sections among their own caste groups. In effect, the Union government is now seeking to ensure a more equitable distribution of reservation benefits by further differentiating caste groups coming under backward classes on the basis of their levels of social and economic backwardness. If the categorization of the creamy layer had been done consistently and uniformly, there would not have been any left need to be differentiate among the caste groups. This decision on subcategorization came on the same day the cabinet decided to raise the ceiling for deciding who remains outside the creamy layer to those earning rupees 8 lakh annually, an increase of rupees 2 lakh. This is cross purposes with the move towards subcategorization, allowing as it does those with higher earnings to enjoy reservation benefits. The reservation pie is limited and no group, whether rich or poor, dominant or sovereign, can hope to gain except at the expense of another social economic category. Vote bank politics has a lot to do with the prioritizing of caste-based categorization over income-based differentiation to identify reservation beneficiaries. Political mobilization on the basis of caste is far easier than on the basis of income, and the BJP is clearly trying to splinter the vote banks of the Samajwadi Party and Rashtriya Janata Dal in Uttar Pradesh and Bihar. The effort is to make other caste groups see dominant castes such as Yadavs as competitors of education and employment. Evidently, this kind of political mobilization is not at odds with BJP's greater stragman of Hindu religious consolidation, but it may still result in leaving out the truly deserving from the reservation benefits. Thank you.